is presented and implemented.
More grievous than the peace and security of the land. What, like I said, it was a mediation. It wasn't an arbitration, and I'm not here, as I said, to say that this one was wrong or this one. I'll present the facts as they are, and that's what it should be binding on all of us, whoever is there. I've spoken to before I came yesterday, I was on the phone for more than with my brother, the Nairi, explaining the circumstances to him in terms of the decision I took. And I have spoken to the Bokunaba, taking time all these periods to be speaking to everybody about it. The governments of the new Patriotic Party and the National Democratic Congress, led by President Nana Addo Dankwa Akufo-Addo and President John Dramani Mahama, asked me to use my traditional mediation mechanisms to find an amicable solution to the situation in Bawku, which both governments shall enforce. But before I continue, please, I said to the President, bear with me to read through all the report, because I don't want a situation where it will be said that they've doctored what I brought. Administrative, judicial, and spiritual authority. However, when the British arrived in Bawku in 1901, in their bid to advance the indirect rule system, they were not satisfied with the Tindani system, so they decided to adopt qualified Tindanis to become chiefs. And in areas where they could not find qualified Tindanis, they appointed other people as chiefs. The Kusasis further contended that it was around this period that the Mamprusis presented themselves to the British as chiefs of their ethnic community in Bawku and got registered accordingly. However, the Tindani position was never abolished as a traditional arrangement. Thus, the chiefs and Tindanis coexisted. But the new Mamprusi rulers became power-drunk and started misusing their authority over the Kusasi landowners, hence a decision by the Kusasis to remove the Mamprusi chiefs and replace them with their own. So when the last Mamprusi chief the year 59. The Chiefs Recognition Act 1959, number 11 of 1959 by Section 3, as amended by the Chiefs Recognition Amendment Act 1959, provided that it shall be lawful where the Governor General deems it to be in the public interest by order to direct that any person named in the order shall not exercise or purport to exercise the functions of a chief, and by the same or any other order to direct that such person shall not reside within a defined radius of any place named therein. On the 5th of December 1966, NLC, the Lieutenant General J. Ankra, who had become chairman of the National Liberation Council, which had replaced the government of Dr. Kwame Nkrumah following a military coup on the 28th of February 1966, 24th of February 1966, promulgated the Chieftaincy Amendment Decree 1966. NLC Decree 112, according to its terms, provided that the recognition of the member of the National Liberation Council responsible for chieftaincy matters shall, for the purposes of Section 1 of the Chieftaincy Act 1961, Act 81, be deemed to have been withdrawn from the person, any person who was chief in any place specified in column 2 of the second schedule to this decree, immediately before any such person as is referred to in column 1 of that schedule was recognized as chief for that place, shall, if he is alive at the commencement of this decree, be deemed with effect from the commencement of this decree to be restored to the stool in the person specified in the said column 1 of the said schedule, and to have been recognized as chief by the member of the National Liberation Council responsible for chieftaincy matters for the purposes of Section 1 of the Chieftaincy Act 1961. The second schedule had in page 7 of the decree a list of names of chiefs from whom recognition is to be withdrawn, and the places at which they acted as chiefs in the upper region. They included Ayamba, Bugari, Timpani, Atu Ayebo, Kusanaba, Pujiga, Tanga, Ayubiogo, Gabari, Adu Bila Asa, Zabila, Abugria, Puzida, Binduri, Akagane, Kugri, Abu Balila Awuni, Zongori, Abaricha Kusasi, Senebaga, Abugri Abango Binaba, Dinko Dant, Warikumbo, Azinab Ayebo Teshi, Anena Akazuza, Pusiga, Awini Adoleba Kulungugu, Awini Achule Bugri, Aburago Azoka Bawku. Thus, Aburago Azoka was removed from office as chief of Bawku and head of the Kusasi area, and the chiefs he appointed to the 15 other subdivisions listed above were also deposed. NLC Decree 112 further provided in the section that the instruments specified in the third schedule to this decree are hereby revoked. One of the instruments listed on page 8 of the decree is titled Jeremiah Mamprusi Prohibition Order 1959. The NLC decree thereby placed the Nairi as the one entitled to enskin the chief of Bawku. Given that Jeremiah Mahama had died before the passage of NLC Decree 112, the Nairi selected and enskinned one Adam Azambego and Mamprusi as the Bawku Naba. The High Court and the National House of Chiefs affirmation of NLC Decree 112. The Kusasi, led by Aburago Azoka, continued to mount protestations against the NLC Decree 112. Kusasis refused to accept the authority of the Mamprusi chief of Bawku and continued to proclaim Aburago Azoka as their legitimate ruler in 1980, when the Third Republican Constitution was in force and the government of Dr. Hila Neman was reigning, Aturiba Azambego, the then Mamprusi chief of Bawku, sought an injunction from the High Court in Bokatanga to restrain Aburago Azoka from interfering in chieftaincy matters in Bawku. This injunction was granted. The Kusasi, led by Aburago Azoka, petitioned the National House of Chiefs, requesting the House to set aside the NLC Decree 112 on the grounds that it offended the Court of Appeal ruling in favor of Aburago Azoka. In 1983, the House of Chiefs declined the invitation and held that it had no jurisdiction to declare NLC Decree 112 as invalid. The Mamprusi chief therefore remained in place. Then the passage of the Chieftaincy Restoration, PNDC Law 75. Following the overthrow of the Third Republican Constitution and the establishment of the military government of Flight Lieutenant Jerry John Rawlings under the PNDC, the Kusasis continued to petition against Mamprusi rule in the Kusasi area. The government of Jerry John Rawlings decided to review the case and came to a conclusion that in the case of Bawku and in the matter of the Kusasis, they believed that the National Liberation Council had committed an error. It was argued that the NLC's focus on chiefs was on chiefs removed by President Kwame Nkrumah. The situation of Bawku was different. The Mamprusi chief was removed by the Governor General upon the recommendation of a committee he had set up. His decision was also affirmed by the then Supreme Court of Ghana. On that basis, the PNDC law decided to restore the Kusasi back to the status of chiefs in Bawku. In all the places where the NLC Decree 112 withdrew recognition for chiefs who were in place in 1966, PNDC Law 75 restored recognition to them. Those that came into force on the basis of NLC Decree 112 were also removed and recognition withdrawn from them. I hereby reproduce PNDC Law 75 herein. Whereas by virtue of Section 3(1) of the Chieftaincy Amendment Decree 1966, NLC Decree 112, the then government of the National Liberation Council withdrew recognition of the persons named in Part 1 of the schedule to this law as chiefs in the places specified respectively, in relation to them. And whereas by virtue of Section 3, Clause 2 of the said decree, and the said persons were prohibited from purporting to exercise the functions of chiefs, and whereas by virtue of Section 4 of the said decree, the persons named in Part 2 of the schedule to this law were accorded recognition as chiefs by the then government of the National Liberation Council and restored as chiefs of the places specified respectively in relation to them in place of the person named in Part 1 of the said schedule. And whereas the Provisional National Defense Council, having considered the circumstances of the withdrawal of recognition by the then government of the National Liberation Council of the person named in Part 1 of the schedule to this law as chiefs, is satisfied that the said person, having been lawfully installed or enskinned as chiefs, should be restored to the original status as chiefs of the places specified respectively in relation to them. Now, therefore, in pursuance of the Provisional National Defense Council Establishment Proclamation 1981, this law is hereby made. Notwithstanding anything to the contrary, the person named in column 1 of Part 1 of the schedule to this law, whose recognition as chiefs of the places specified respectively in relation to them in column 1 was withdrawn by virtue of Section 3 of the Chieftaincy Amendment Act 1966 NLC Decree 112, shall, at the commencement of this law, be deemed to have been restored to the original status as chiefs of their respective places. Any person specified in Part 1 of the schedule to this law, who before the commencement of this law is performing the functions of a chief by virtue of Section 4 of the Chieftaincy Amendment Decree 1966 NLC Decree 112, in any place specified in column 2 of Part 1 of that schedule, is hereby prohibited from purporting to exercise such functions, and it shall be unlawful for any person to treat such person as a chief. 3.1. Any person referred to in Section 2 of this law, who has in his possession or custody any property belonging to the stool or skin of any of the places specified in column 2 of Part 1 of the schedule to this law, shall, with the commencement of this law, surrender such property to the person named in column 1 of Part 1 of that schedule and restored under Section 1 of this law as chief in the place specified in relation to him in column 2 of that part. Any person referred to in Section 2 of this law who occupied any palace belonging to the stool or skin of any of the places specified in column 2 of Part 1 of the schedule to this law shall immediately, on the commencement of this law, vacate such palace and surrender possession thereof to the person named in column 1 of Part 1 of that schedule and restored under Section 1 of this law as chief in the place specified in relation to him in column 2 of that part. Any person who willfully obstructs the person authorized to take possession of any stool or skin property, refuses to vacate the palace, willfully obstructs the restoration of any stool or skin property, or contravenes any provision of this law, shall be guilty of an offense and liable on summary conviction to imprisonment for a term of not less than 3 years without the option of a fine. And then it listed the same names, so restoring the names as it is now again. So Abugra Azoka becomes Bokunaba again. And Alaji Adam Zambio then ceases, is prohibited from becoming, from being Bokunaba. The passage of PND's Law 75 led to bloody clashes between the Mampruses and the allies and the Kusasis and the allies. Other complementary measures were implemented by the PNDC to restore law and order. They included the Bawku Lands Vesting Law, PNDC Law 99, which vested all lands in the Bawku district and the PNDC free from all encumbrances, and the passage of the Prohibited Organization Bawku District Law 1984, PNDC Law 98, which proscribed tribal organizations in Bawku. Abugrago Azoka had died before the passage of PNDC Law 75. The Kuskasis then enskinned his son as Asigri Abugrabo Azoka as the Bokunaba and the head chief of the Kusasi traditional area. The Constitution of Ghana, 1992, came into force with the Kusasis in place as the rulers of Bawku. Asigri Abugurago Azoka was Bokunaba, and by virtue of that, he enskinned all the divisional chiefs in the Kusasi traditional area. Article 270, Clause 1 of the Constitution provides that the institution of chieftaincy, together with its traditional councils, as established by customary law and usage, is hereby guaranteed. So the position of Asigri Abugra Azoka seemed to have been frozen in time by the 1992 Constitution, until one Alhaji Ibrahim Adam Zambio mounted a challenge in the present Supreme Court. This 2003 action instituted by the man process before the Supreme Court, seeking to invoke its original jurisdiction, was discontinued without liberty to reapply under Article 270 and 277 of the 1992 Constitution and the Chieftaincy Restoration of Status of Chiefs Law, 1983 PNDC Law 75, which had then been repealed by the Statute Law Revision Act 1996, Act 516, in 1996. On Tuesday, the 29th day of April 2003, the Supreme Court of Ghana provided what legal analysts believe to be finality to the question of the Bawku skin. The ruling was very short and yet profound. Report says, the application to discontinue is granted, but without liberty to apply PNDC law, liberty to apply under PNDC law 75 and Article 270 and 277 of the 1992 Constitution. Cost of those days, 10 billion to the first defendant. Signed, G.K. Akwa, Justice of the Supreme Court, T.K. Aziz, Justice of the Supreme Court, S.A. Brobe, Justice of the Supreme Court, S.G. Beidu, Justice of the Supreme Court, Dr. S. Chum, Justice of the Supreme Court. Apparently, on the morning of the hearing of the matter, the plaintiffs instead sought leave to discontinue the case. The leave was granted, but the court directed that no one should come back to that court again pursuant to Articles 270 and 277 of the 1992 Constitution, the matter of the restoration of Abugrago, Azoka, and all other sub-chiefs under PNDC Law 75. Under the 1992 Constitution, the Supreme Court has final authority to make such pronouncements, and only that court can review its decisions under certain circumstances. I've gone to great length to review the history of various legal resolutions of the matter and the involvement of the various military regimes to show that this matter has traveled a long, tortuous legal and political journey. In spite of the efforts of various courts and governments, the Memphis did not give up their claims, and the Kusasis did not relent in their efforts to assert their independence and identity as a self-ruling tribe. The Nairi kept insisting that the Supreme Court has not ruled on the issues implicated in the Bawku skin matter. Asigri Abugrago Azoka insisted that the Supreme Court gave finality to the matter. This contestation led often to extreme violence, and many people have been gruesomely killed and maimed. Property that can be easily calculated has been destroyed. Whole communities have relocated because all the buildings have been burned by various factions. The intensity of the violence did not deter either side. They dug in. Governments from PNDC to NDC-1 to MPP-1 to NDC-2 and MPP-2 have invested heavily in security and other measures with very limited success as the violence kept escalating. Within these developments, the Mamprusis in Bawku organized a funeral for the last deposed Mamprusi chief of Bawku, Na Tampuri Zambio, who had died in 1981, 40 years ago. The Kusasis in Bawku had objected to the performance of the funeral on the grounds that Na Tampuri Zambio had his chieftaincy recognition withdrawn by the passage of the Chieftaincy Restoration Status of Chiefs Law 1983, PNDC Law 75. Again, the Nairi of Mamprugu on 15 February 2023 at his palace in Nalarugu purported to enskin one Mr. Seydou Abagari as Bokunaba. This generated a violent reaction in Bawku and its environs. The government of President Nana Dankwa Akufo-Addo promptly issued a statement same day denying the legitimacy of that act. Government condemns developments in Nalarugu today, February 15th, 2023. concerning the purported enskinment of a new Bawku Naba as illegal and a threat to national security. Government further reiterates that Naba Asugri Bugrabo Azoka is the Bawku Naba, duly gazetted and a member of the National and Upper East Regional House of Chiefs. The security agencies have therefore been directed to arrest and prosecute any other person who holds himself out as Bawku Naba. This statement was signed by Mr. Kojo Nkrumah as Minister for Information. The government of Nana Addo Dankwa did not arrest Seydou Abagari. The government continued to reject as illegal what happened in Narugu and repeated same in another statement dated 28 October 2024 when Seydou Abagari returned to Bawku. The statement read in part, the return to Bawku on 24th October of Mr. Seydou Abagari, who was illegally enskined as Bawku Naba in February 2023, subsequent to the vacation by the Court of Appeal sitting in Kumasi of the warrant for his arrest, has led to significant disturbances affecting public peace and security in the area. The government did not in any form or manner confer legitimacy on Mr. Seydou Abagari. As I indicated from the beginning, I was requested by the New Patriotic Party government to mediate in the matter. President John Dramani Mahama, who assumed office on the 7th of January, endorsed that I should proceed with finding an amicable resolution to the current situation. The parties in this dispute have willingly submitted themselves to the mediation process. The Bawku Naba Sigiri Abugaragu Azoka has accorded me enormous respect and personally led his delegation at all times to my palace whenever invited. My brother, the Nairi, has for very good reason, sent a delegation of his elders and sub-chiefs at all times that I have requested him to come. They all express confidence in the process and believe that we will be able to work towards an amicable outcome. I started my engagement with my brother, the Nairi, by appealing to him to magnanimously recognize the position of the law that the Kusasi should rule themselves. After careful consideration, the Nairi made some concessions but gave some conditions for my consideration. Essentially, my brother, the Nairi, wanted the historical acknowledgement of his ancestral ownership of the entire land that now constitutes the Bawku traditional area. He acknowledged that the Kusasis have come to largely occupy that area. Both Kusasis and the Mamprusis who are now occupying those lands are his children. He observed that as a result of colonial interference and interference of various governments, Kusasis have asserted self-rule and now lay claims to the chieftaincy of the area. The Kusasi claim has caused significant bloodshed between them and his Mamprusi children, and this has spread across the area and now poses a major national and international security threat. The Nairi detested that development and finds it most unfortunate that such bloodshed should occur among his children. He therefore sought an amicable compromise to end the feud and restore lasting peace. He said in part, "Be that as it may, in the interest of coexistence, peace and human dignity, my proposed solution and concessions is premised on the request from your Royal Majesty that I cede part of my jurisdiction in the Bawku traditional area to the Kusasi tribe, with the hope that a lasting and enduring peaceful resolution of the Bawku conflict will be achieved for all parties." The Nairi has been clear in his mind that his decision to make concessions has been a difficult one, but added that, nonetheless, guided by ancestral wisdom, commitment to peace, and respect for Your Majesty's tireless efforts, I have chosen the path of conciliation, not out of weakness, but as a testament to Mampurugu's strength, dignity, and unwavering commitment to the well-being of all communities in the Bawku traditional area. I had been inspired by the desire and commitment of my brother, the Nairi, to bring a peaceful end to the conflict in Bawku and its environs, and to define the best arrangements to accommodate all the different tribes and communities in the area. The Nairi outlined a set of proposals which form the basis of engagement that I have had with both sides with the hope of finding a common ground. If a common ground emerged, it would enable them to reach an amicable resolution. With this historical understanding, I have impressed upon the Bawku Naba, Sigri Abugrabu Azoka to acknowledge that at one time or another, the Nairi exercised traditional authority over the area that now constitutes the Bawku traditional area. I concede that colonization by the British might have played a role in the establishment of the chieftaincy institution across the area that now makes up the Kusal Traditional Council. Records has it that at various times, the Nairi enskinned the Bawku Naba, and the latter then enskinned the various sub-chiefs in the Bawku traditional area. It is this state of affairs that the Kusasi challenged since 1957 until PNDC Law 75 was passed in 1983. The passage of PNDC Law 75 defines the resolution of the situation in Bawku. I have as well impressed upon my brother the Nairi that current realities make it more pragmatic that we accept Kusasi rule over the area. With the passage of PNDC Law 75, the coming into force of the 1992 Constitution of Ghana, and the ruling of the Supreme Court in Alhaji Ibrahim Adam Zambego versus Aninchema Abugrago and Attorney General, it will be untenable for anyone to hold that Sigri Abugrago Azoka is not the Bawku Naba and exercises jurisdiction over the entire Kusasi area. The Supreme Court shuts its doors to anyone seeking to have the matter revisited. It is important to note that PNDC Law 75 was repealed alongside several laws and enactments by the Statute Law Revision Act 1996, Act 516. The long title of the Statute Law Revision Act 1996, Act 516, which repealed the Chieftaincy Restoration Statutes of Chiefs, later Chiefs Law 1983, PNDC Law 75, among other laws and enactments as indicated above, provides as follows: an act to repeal certain statutes that are no longer applicable or have become spent. It therefore appears that the Chieftaincy Restoration Statutes of Chiefs Law 1983, PNDC Law 75, just like the other laws and enactments that were repealed by Act 316, were repealed because they had performed the purpose for which they were enacted and thus had become spent. Its repeal, therefore, did not create a vacuum, just like the other laws and enactments repealed with it. Rather, the status quo at the time of the repeal of PNDC Law 75 by Act 516 was to be maintained. Response to the Nairi's terms of concessions. In spite of the clarity of the law on the matter, I still continue to engage my brother the Nairi on the terms of concessions presented by him to me. Essentially, he asked for a number of towns in the Kusasi area to be transferred to him to enskin. The impression created was that those towns would prefer to be under the Nairi essentially. The request was to have some of the towns brought under the jurisdiction of the Nairi. I decided to engage the chiefs of those towns. After meeting the various chiefs of the towns and communities affected by the withdrawal of recognition following the implementation of the Governor General's White Paper in 1957, on the recommendations of the Afari Committee, the withdrawal of the recognition occasioned by the NLC Decree 112 and PNDC Law 75, I have come to the conclusion that there has been significant reconciliation among the various Kusasis and Mamprusis in all the other towns. Bawku was mentioned in the proposed terms of settlement of the Nairi as one of the towns that the Mamprusi wanted to be given to the Nairi. Unfortunately, the law as it stands now makes Asigri Abugrago Azoka the lawful chief of Bawku, and so it is impossible legally to do any such thing in this mediation exercise. On the question of Bawku town, I have taken the position that the established tradition since 1931 thereabout is that the person who is Bawku Naba has the entire Kusasi area. By law and the declarations of the Supreme Court of Ghana, Asigri Abugrago Azoka is a Bawku Naba, and there cannot be any rival residing in Bawku claiming otherwise. I have impressed upon my brother the Nairi to accept that recognition by law in appreciation of the enduring brotherhood that has existed between our two kingdoms in order to ensure lasting peace and eliminate the national and international security threats that my brother himself is so concerned about. I have been candid with my brother, the Nairi, that the purported enskinment of Mr. Seydou Abagari as Bawku cannot stand. I believe my brother, the Nairi, has come to terms with the difficulties that will pose to achieving lasting peace, which he desires. I have, from the inception, restrained both governments from effecting the arrest of Mr. Seydou Abagari, out of respect for my brother, the Nairi. The final resolution of the Bawku matters requires that Mr. Seydou Abagari be recalled to Nalerigu by the Nairi to be reassigned to play another traditional role at the palace of the Nairi, assisted by the state. Alternatively, he may choose to stay in Bawku as an ordinary citizen of the community, but not to pose as Bawku. The final recommendation, Mr. President, I recommend that my brother, the Nairi, accepts the laws as presently constituting Sigri Abugrabu Azoka as the chief of Bawku and head chief of the Kusasi traditional area. We chiefs, no matter how exalted, do not live above the Constitution of Ghana and the laws duly enacted and affirmed by the courts. Accordingly, the laws which recognizes Sigri Abugrabu Azoka must be enforced by the government of the Republic of Ghana until changed in accordance with the 1992 Constitution or reviewed by the Supreme Court of Ghana. The government must enforce the laws and deal sternly with any person challenging the lawful authority of the Abugra Asoga. This is critical to the restoration and maintenance of peace in Kusasi traditional area. I wish to thank you, Mr. President, and your predecessor for reposing such confidence in me and tasking me with the mediation of this conflict with a view to finding a lasting solution. I also want to thank the Nairi and the Bawku for their efforts relative to this mediation process. The various chiefs or heads of various communities whom I met in the area who also participated in this endeavor deserve positive commendation. I have come to the conclusion that the path to a lasting resolution coincides with the enforcement of the current position of the law by the laws of Ghana and by the Constitution enacted in 1992 and by the position of the Supreme Court that the matter should never be litigated before it again, as Sigri Abugrago Azoka is the lawful chief of Bawku and the paramount chief of Kusasi traditional area. He has been a member of the National House of Chiefs for about 40 years. He has been duly gazetted. His right to rule should not be disturbed, save through a judicial and constitutional recognized process, and which, as already indicated, appears, if any, a review of the pronouncement of the Supreme Court of the Republic of Ghana stated herein. If the pronouncement of the Supreme Court appears not clear enough, remedy may be sought, if available, for clarification of the same by the Supreme Court. Either way, Bawku and its environs will be assured of sustainable and enduring peace. Mr. President, thank you very much. I appreciate it. Mr. President, I want to suggest that I was going to meet them again. We set up a mediation process where we would, reconciliation and everything, the way things have happened, where the Peace Council, and then we nominate some lawyers from their side, from each side, and others, and we form a committee to go through that. Then we start a reconciliation process. Whilst talking to them, I realized also that arms and everything were there. And all those, I spoke to them. I think we can find a way to get them to go and find a safe place for them to go and leave it. Maybe an appeasement of some 500, going, not by the government, by the National Peace Council, myself and some people, we can do that also. That I tested the pulse and I believe it can be done. So now it's up to you to implement what I have said, Mr. President. I wanted to read that because I didn't want it to come from you, for them to charge you that you've changed the report. So
Please be seated. Please.